Welcome back to the Supreme Court Historian YouTube channel. In this video, we will be looking at the second freedom of speech and expression judgment given by the Supreme Court of India on the 26th of May 1950. We've already looked at the first of these two decisions, the Romesh Thapar case, in the previous video. In this one, we will be looking at Brij Bhushan's case, Brij Bhushan versus the state of Delhi. The facts are that this particular English weekly, the Organiser, which was basically the mouthpiece of the Rashtriya Swayamsevak Sangh, had been publishing in February 1950 several articles critical of the government of India, the central government led by Prime Minister Jawaharlal Nehru. The criticism was directed towards his policies dealing with the Muslim evacuee property, especially. These post-partition days saw a very difficult time faced by the people of India and consequently by the government of India. But the Organiser was especially focused on what was happening in East Pakistan. By now, West Pakistan had simmered down, but East Pakistan saw some sort of almost a pogrom against the Hindus, especially in the capital Dhaka, resulting in hundreds of thousands of Hindus escaping from East Pakistan into West Bengal, especially, and also Assam, but basically West Bengal. And while this was happening, the government was being encouraged by people like the RSS and the Hindu Mahasabha to confiscate the property that had been evacuated by Muslims who had moved from India into Pakistan and grant that property, distribute that property amongst those who had come the other direction from Pakistan into India as a punishment for what they had been doing over there. The Organiser and its readership, perhaps its senior readership, if we can call it that, were also involved in convincing the people in somehow annulling or rolling back partition and calling for Akhand Bharat. All of this was done in a very critical tone. I have pasted one sentence from one such article, that the villainy of Pakistan is matched only by our idiocy. And there were several cartoons of Liaquat Ali Khan and Prime Minister Jawaharlal Nehru at the time when Nehru was trying to initiate some sort of confidence building measures with his Pakistani counterpart. All of this resulted then in the Chief Commissioner of Delhi issuing pre-censorship order on the Organiser. What this meant was that the Chief Commissioner of Delhi called upon the Organiser magazine to submit its articles, cartoons, photographs, anything that was original material that was not created out of standard sources such as the wire agencies, the UNI, etc., UNI, PTI, and so on. Instead of that, anything that the Organiser was creating on its own was to be submitted for pre-censorship. Before printing, it had to be approved by the Commissioner of Delhi. This was being done under Section 71C of the East Punjab Public Safety Act 1949. The act, although passed for the state of East Punjab, had been extended to the province of Delhi by the Delhi government, and that is why the Delhi Chief Commissioner was empowered to pass such an order which he claimed was necessary for the purpose of preventing or combating activities prejudicial to the public safety or the maintenance of public order. Once again, public order comes into the picture, just as it had in the Romesh Thapar case, the government claiming that public order was being prejudiced by the activities, by the publication, in that case of the communist journal Crossroads, in this case by the right-wing journal, the Organiser. Apart from that irony, the fact remains that this was a government in independent India now resorting to the exact policies resorted to by the British. Just like preventive detention, we now had pre-censorship of the press, which was first seen in our country by the Vernacular Press Act of 1878 that was passed by the Viceroy Lord Lytton. Lytton, of course, consequently made a significant contribution to our freedom struggle, unknowingly, unwillingly, because he managed to coalesce the freedom struggle in opposition to him. The protests against Lytton's 1878 Vernacular Press Act was led by Surendranath Banerjee, who became one of our first national leaders, and eventually which led in 1885 to the formation of the Indian National Congress. Lytton, of course, was recalled, and his successor, Lord Ripon, repealed that Vernacular Press Act of 1878, which is why we remember Ripon fondly. But people like me like to remember Lytton fondly as well, because without his actions, perhaps our freedom struggle would not have received the boost that it did. So people like Lytton and later on Curzon, etc., these are also our unsung heroes in the freedom struggle. Nonetheless, coming back to the point that is being attempted to be made in a very dilatory fashion, is that this kind of pre-censorship was seen under the British rule even in the early years, in it as early as 1878, and now it was 80 years, 70 years later, it was being seen in independent India. Obviously, the organizer and its leaders were not going to take these kind of threats lying down. The editor of the magazine, Mr. K.R. Malkani, it appears as a typo in the judgments that we get to read today as Halkani. Obviously, Malkani was scanned incorrectly by the software and it reads as Halkani. The M has become an H, but it was Mr. Malkani. He wrote an editorial just 4 days after the initial order by the Chief Commissioner of Delhi, criticizing this order and writing very eloquently that a government can always learn more from bona fide criticism of independent thinking citizens than the fulsome flattery of charlatans. Once again, the language could have been a bit more moderate, perhaps, but they were the ones who were suffering at the hands of the government. Pre-censorship is about the worst thing that you can do to a journal or a magazine. And that is what Mr. Malkani and his organizer were suffering. Mr. Malkani, incidentally, a few years down the line, suffered at the hands of the government of Jawaharlal Nehru's daughter as well. He had the dubious distinction of being the first person to be arrested when Indira Gandhi declared the emergency in June 1975. Much before that, we are still in 1950, 25 years before that arrest, before that detention, when Mr. Malkani and his publisher and printer, Brij Bhushan, challenged the Delhi Chief Commissioner's pre-censorship order to be violative of Article 19(1)(a), freedom of speech and expression, and exercised their fundamental right to approach the Supreme Court under Article 32. The case then was listed as Brij Bhushan and another versus the state of Delhi. The irony being then that the same article was being used, Article 19(1)(a), by the communist leaning weekly and by the right-wing leaning weekly. And for those of us who are tickled by these kind of ironies and paradoxes, here's another one. Brij Bhushan and Malkani were represented in this case by Mr. N.C. Chatterjee. N.C. Chatterjee had already been the president of the Hindu Mahasabha before he took on this case. Nothing surprising about that. What is interesting and ironical is that his son is more well known as the Speaker of our Lok Sabha from 2004 to 2009. I am speaking, of course, of Mr. Somnath Chatterjee, one of the most respected modern leaders of the Communist Party of India, Marxist. So a Hindu Mahasabha president and his son was a communist leader. The ironies don't end here. Brij Bhushan's opponents, the state of Delhi, were represented by MC Setalwad, Attorney General, of course, and also by S.M. Sikri, the additional Advocate General of Punjab. Mr. Sikri, as he then was, later on rose to be the Chief Justice of India. And while this particular case eventually led to the passage of the First Amendment of the Constitution, Mr. Sikri himself, when he was Chief Justice, restricted the amending power of the government, of the legislature, of the parliament, in the very famous Keshwananda Bharati judgment, which he gave a couple of days before his retirement as the Chief Justice of India. So the ironies abound, but the case was quite straightforward, especially given the fact that Rumesh Thapar was being concurrently heard and adjudicated upon. The argument made on behalf of Brij Bhushan and Malkani was quite straightforward. Pre-censorship does not fall in the restrictions that have been enumerated under Article 19.2, the restrictions which we have already looked at in the Rumesh Thapar case, that is security of the state, etc. Pre-censorship surely cannot be allowed as a restriction to the freedom of speech and expression. The state of Delhi made the same argument that the state of Madras made in the Ramesh Thapar case, that these activities will fall under the security of state because they are violating public order and public security. And in this particular case, since these articles were even going to the extent of calling for the annulment of partition, by the forceful annulment of partition, and calling for an Akhand Bharat, they were therefore threatening the security of the state. The argument fell on deaf ears. The Supreme Court was not willing to give a wider reading to any provisions at this early stage of the Constitution. We are still, remember, within the first few months of our republic. This is still May 1950. And the Supreme Court was going to take as literal a reading of the Constitution and of statutory provisions as well. So the particular provision that had been utilized by the Chief Commissioner, Section 71C of the East Punjab Public Safety Act, was held to fall foul of Article 19.1, was not held to succeed in the list of restrictions given in Article 19 Clause 2, and therefore it was held that the order which called for pre-censorship was void. In fact, to quote from the judgment, as this question turns on considerations which are essentially the same as those on which our decision in Petition 16 of 1950 was based. Petition 16 of 1950 was the Ramesh Thapar case. Our judgment in that case concludes the present case as well. Accordingly, for the reasons indicated in that judgment, we allow this petition and hereby quash the impugned order of the Chief Commissioner of Delhi dated 2nd March 1950. A very, very straightforward judgment in the Brij Bhushan case. Brij Bhushan versus State of Delhi, decided on the same day, pretty much literally exactly after the Ramesh Thapar case, right after that, on the same day, 26th of May 1950. A very straightforward judgment, especially after having discussed in detail the Ramesh Thapar case, and quite interesting that the government was censoring or preventing the distribution of documents of written propaganda by the left wing as well as by the right wing. The ramifications of these two judgments and the impact of them will be looked at in the next video. And then after that, in this very playlist, we will also look at the third case which was decided on the same day, also dealing with Article 19, but Clause 1D, that is the NB Khare case. So those are our forthcoming videos. Hopefully you will join me then as well. Have a good time. Bye-bye.